All right, hi, welcome back. Attorney Steve Vondran here. We are talking about torrent litigation in this video. We are talking about strike three holdings, and we are talking about a huge case that came out of United States District Court for the District of Columbia, basically telling strike three, you're out of here. All right, so this is general legal information only and not legal advice. Happy Turkey Day weekend. I hope you guys are all having a great holiday, not getting too stuffed on your turkey, having a good time, getting together with your family and friends. But this case came out. I had to hit it with my fans here, my peeps, the breaking news. This came out a couple days ago, and you can see the case number up here, 118CV01425. And this is out of the District of Columbia Federal Court here, okay? This is strike three holdings versus John Doe. You may say, well, who's John Doe? Well, that's a name they don't know. It's an internet IP address, a subscriber, an IP address that strike three holdings is suing. Now, usually, I would say many cases, if not all, these are done by the law firm Fox Rothschild, and this one was filed by the Fox Rothschild firm in Washington, D.C. Now, as you know, or those of you who have been following my torrent videos know, what happens in these cases is they sue a John Doe and then they seek early discovery. They want to get some discovery going. Usually you have to wait till a scheduling conference, and in this case, in every case, they want to get right to it. They want to send a subpoena to the ISP, like Comcast, okay? They want to send a subpoena and find out who is this IP address right here? Who is that IP address? Who's the subscriber? Well, you know, that's what they're trying to get. In many cases, in California, many cases I handle up in the Northern District, Central District, Southern District, you know, the judges routinely grant these motions. They say, fine, you're looking for the subscriber. Sounds like a plan. Go for it. Send them a subpoena to the ISP, get the name and address and whatever, and do what you need to do with it. So this court said, no, that's not going to satisfy us. This isn't going to satisfy the pleading standards. Getting that address, that IP address, that's not going to necessarily prove who the infringer is, your alleged infringer of the copyrights, these adult pornographic movies. So let's take a look at this opinion. Let's walk through it a little bit, and maybe we can learn a little bit more about these. If you're facing a strike three holdings case, whoops, there's a call now. You know, this is going to be an important video, especially if you're in the District of Columbia. This is especially important. So at any rate, so let's take a look at the decision here. Strike three holdings LLC, I'm starting from the top here, produces award-winning, critically acclaimed adult motion pictures. So this is what I call kind of the boilerplate complaint that you can see. It's kind of boilerplate facts in every type of case. So this judge didn't really appreciate that standard and really, to me, hit right between the eyes, strike three holdings. Or as the Miami Herald describes it, it is the Steven Spielberg of porn. So they talk about that a little bit. That's a complaint. Here they are in the Miami Herald. By the way, speaking of the Miami Herald, there was a newspaper article that was put out. I couldn't believe it. I read it, and it was from Strike Three Holdings and one of their attorneys, and they were talking about how Strike Three is different from Malibu Media. Malibu Media is the other big adult pornography company that likes to file suits for copyright infringement. So we're different. We're not actually trying to make money. I was like, what? Oh, you're not trying to make money? Well, you know, I've seen legal demands as much as $50,000. You mean that's not trying to make money? So, you know, it's those kinds of things. And here they're cited in here, the Miami Herald. So here they are again. So don't believe that. In my opinion, that is designed to get you to call them and call their lawyers and say, hey, you know, I got a subpoena, and, you know, since you're not trying to make money, I would just happily like to work this out. And, you know, I think that's the trap. So don't do that before you ever call their attorney or do anything like that. You should get legal advice. This is very important. Let me tell you why. Do you think you're ready to face a $20, $30, $40, $50,000 legal demand? Are you ready for that? Most people aren't, okay? But that's what we see over here at our firm, okay? So the reality is You may say they're not trying to make money. Those are your demands. You judge for yourself, okay? But let's get back to it here. Listen to this. Listen to what the judge says here. Strike 3 is also a copyright troll. Okay, so I had another media ask me the other day, you know, what's a copyright troll and why are they, you know, why are certain companies copyright trolls? Well, here it is. It's not coming from me. This is coming from a judge in the federal district court in DC. Strike 3 is also a copyright troll. It swarms of lawyers hound people who allegedly watch their content through Bittorrent, an online service enabling anonymous users to share videos despite their copyright protection. Since Bittorrent makes users' identities, Strike 3 can only identify an infringer Internet Protocol IP address using geolocation technology to trace the address to a jurisdiction. This method is famously flawed. Virtual private networks and onion routing spoof IP addresses for good and ill. Routers and other devices are unsecured. Malware cracks passwords and open backdoors. Multiple people, family, roommates, guests, neighbors, etc. share the same IP address. A geolocation service might randomly assign addresses to some general location if it cannot more specifically identify another. So the court is pointing out some of the inherent flaws in this system here. So let me see if I can go down. Okay, what's going to break me into two pieces here? It goes on to say, simply put, inferring the person who pays the cable bill, inferring that they illegally download a specific file is even less trustworthy than inferring they watched a specific TV show. But in many cases, the method is enough to force the internet service provider to unmask the IP address subscriber. And once the ISP outs the subscriber, permitting them to be served as the defendant, any future Google search of their name will turn up associations with the websites, Vixen, Tushy, so forth. The first two are awkward enough, but the latter two cater to even more singular tastes. Little wonder so many defendants settle, what we call the shame settlements. You don't want your name appearing in a lawsuit, and that's why these fees go up. That's why the penalties, demands, and damages are up in the amounts that I'm telling you. These are routine demands that I see, okay? According to Pacer, over the past 13 months, Strike 3 has filed, look at this, 1,849 cases. 1,849 cases, just like this one in courts across the country. 40 in this district alone, closely following the copyright trolls, who together consumed 58% of the federal copyright docket in 2015. So this was a couple years back, but almost 60% of the copyright docket is these types of cases. These serial litigants drop cases at the first sign of resistance, preying on low-hanging fruit and staying one step ahead of any coordinated defense. They don't seem to care about whether a defendant actually did the infringing or about developing the law. If a Billy Great Gruff moves to confront a copyright troll in court, the troll cuts and runs back under its bridge. And this is the federal judge really just hammering them on this. Perhaps the trolls fear a court disrupting their rinse, wash, and repeat approach. File a deluge of complaints. Ask the court to compel disclosure of the count holders. Settle as many claims as possible. Abandon the rest. Some citations there. Here, this approach led Strike 3 astray because Strike 3's need for discovery does not outweigh the defendant's privacy expectation. This is the key to this decision here, is that, you know, when you get cable, satellite TV cable, whatever, you have an expectation that this is just kind of be a private contract with a private party. And you do have an expectation of privacy is what the court is saying here. And the need for this early discovery to send a subpoena to, you know, Comcast, Verizon, Charter, whatever, does not, the privacy expectation outweighs their need for this discovery, especially when it's not guaranteed to produce the infringer. And so it says a court will deny strike three's ex parte motion to subpoena defendant's ISP to discover defendant's identity prior to the 26F conference. Okay, that's the conference I talked about. That usually you have the conference and then you can go do all the discovery you want. Have a great time. Good luck. That sunders strike three's entire case, since a failure to identify defendant makes effectuating service impossible. So the court will dismiss this case without prejudice. Means it could be brought back again if they went and came up with some better information. But there were several declarations that you can find. I'm going to post them on a blog. Several declarations that were provided in support of this early motion. One from the investigation company, one from the owner of the company, and two others. But anyway, and so what the court goes on to say, strike three's request for early discovery falls short of Rule 26's requirements. A plaintiff can only discover an unknown defendant's identity through a court order under Rule 26d1. But the rule cabins the district court's discretion to order discovery to circumstances where a plaintiff shows good cause. And to show good cause, the D.C. Circuit Court, now this doesn't mean it's going to apply in California or Illinois, New York, Florida, other places where these cases are filed. It just says here, the D.C. Court requires establishing likely personal jurisdiction. Here, strike three clears that hurdle, suggesting using geolocation services to track an infringing IP address to D.C. justifies a good faith belief that the court has personal jurisdiction. Yet the D.C. Circuit never said that was the only requirement. They never said that. For one, the court must also balance strike three's need for discovery with a potentially non-infringing defendant's right to be anonymous. That's what we were talking about. Only the Second Circuit has articulated this balance, looking to the plaintiff showing of a prima facie claim of actionable harm. Their discoveries request specificity, their alternative means to obtain the subpoenaed information, the need for subpoena information. Okay, so that's going on. What else do we have here? Anything good? So they apply this test. They say here, strike three's request lacks the type of specificity the Second Circuit Court's test requires, that the request will identify a copyright infringer who can be sued. That's what I'm talking about. You don't know when you just have a subscriber's ID. I could invite 10 people over to my house. I could be running a business with tons of people. I could have a corporation with open Wi-Fi for all visitors and guests to use. I could be a fraternity house. I mean, just because you have the subscriber's IP address doesn't mean you know who it is. So this was not enough in this DC court. What else do we hear here? Let's just take a paragraph here. An honest copyright holder might balk at this result, misunderstanding it to slash congressionally endowed defenses against increasingly creative and covert cyber pirates. But the typical case does not involve pornography, nor is it even the run-of-the-mill porn. By extension, two factors limit today's holding. First is the content's aberrantly salacious nature. So the salacious nature of the film. Second is the legion pitfalls associated with strike three's tracking and identification of infringers. So they're saying it's not a perfect science. There's a lot of pitfalls in it. The court will not accept the risk of misidentification. So I think you get the gist of it by now. Because strike three fails to do so here, it cannot subpoena the ISP. So this is, again, huge breaking news here. I had to get this to you and let you see it. As you can see here, conclusion, armed with hundreds of cut and pasted complaints and boilerplate discovery motions, strike three floods this courthouse and others around the country with lawsuits smacking of extortion. Do you hear that? Do you hear that? Smacking of extortion. It treats this court not as a citadel of justice, but as an ATM. Its feigned desire for legal process masks what it really seeks for the court to oversee a high-tech shakedown. This court declines. So there it is, motion denied. Without prejudice, again, doesn't mean it's completely over. They could They could just say, hey, we're out of here. This is getting a little too hot. Judge doesn't like us. Judge Royce Lamberth, United States District Judge. So that's breaking news. And like I said, don't be fooled by some of the things you read, some of the things you hear. If you get a notice of ISP copyright infringement and you're being named as a John Doe, call us up. We can look up and see how many movies are at issue. We can talk to you about the process, what you can expect. And again, don't think you might read something online, oh, we're just your friends. We're just trying to make sure everybody's happy here and the copyright holders are just, trying to, don't be lured into that, because once you call one of their lawyers and they're taking notes, they may be taking truthful notes, they may be taking false notes. Who knows? Who knows? But call us for a free initial consultation. We can help you weed through it a little bit and help you understand. And we are one of the leaders in the United States in representing torrent clients. And in this area of law, there really is no substitute for specific federal court litigation experience, torrent litigation experience, and that's what we have. Some people like to just call a family lawyer or a criminal lawyer, but we often get referrals from these lawyers because people know if you haven't been there, done that, and dealt with these companies, that you really don't know how to handle it. But Strike 3 Holdings, Malibu Media, FlavorWorks, those kinds of movies, give us a ring. We can help you out. Attorney Steve, get back to your Thanksgiving weekend, your Turkey Day. Have some fun. Make sure if you like this video, give me a thumbs up. It keeps me going. Keeps me going. And hope you enjoyed this video. Thanks a lot. Have a great week.